Good morning.
Morning, Your Honors.
This case that's before us now is Hutchison versus Kaforey. And each side will have 15 minutes to present their arguments. So I know there are multiple appellees, but I'm sure it's explained to you that you just get 15 minutes. And the court is ready to proceed. When you are ready to proceed, and the appellant may reserve up to 5.
Thank you.
And I will be keeping time, so if anybody needs any help with that, let me know.
If it pleases the court, I'd like to divide 11 into 4.
That'll be fine.
If it pleases the court, my name is Mark Ludwig. I have the privilege of representing appellant Mary, formerly Hutchison, now Barnes, the mother of the decedent Mike Hutchison. We'd ask this court to reverse a grant of summary judgment dismissing claims contesting a will on the basis of lack of capacity and undue influence. Separate but interrelated claims in that the courts have made clear that the evidence for one can be part of the evidence for the other. The standard of review for grant of summary judgment is not really in dispute. It's de novo. All the sides seem to agree on that. The point we'd like to emphasize in argument is there is no deference given to the trial court decision. Too often I've spent time in summary judgment cases arguing why the trial court was wrong when I should be arguing what this court should do on summary judgment, because it is de novo review. The elements of summary judgment are also not in dispute, but two factors we'd like to emphasize as this court reviews whether summary judgment was properly granted. And that is, first, is this court going to, and was all of the evidence viewed in Mrs. Barnes' favor as it must be on summary judgment? And secondly, and I think relatively importantly, trial courts seem to forget the principle that on summary judgment you're not weighing the credibility of witnesses. You're literally seeing if there is some evidence in each hand that could be reasonably support a verdict one way or the other. Please, I'm sure this court has emphasized both of those elements of summary judgment, but we want to raise them again in oral argument. This case begins with two presumptions. The admission of a will to probate, which is prima facie case of validity of the will. It falls away, however, in light of any other evidence. The second presumption that arises is that this will was made during a guardianship. While the person had been in guardianship and had been in guardianship for years, the presumption there is that he lacked capacity to make a will. Finally, a third presumption does arise from the evidence even movements offered in this case, and that is Ms. Kaforey, as guardian and attorney for Mike, was undoubtedly in a fiduciary capacity when she made the will on his behalf. To Mary's view, first of all, the face of the will raised some suspicions. The face of the will made a gift to Altoona Children's Services, and we can find no evidence such a thing ever existed, and you would think that the movement saying the will is valid would be able to show that those named existed. We claimed the attestation clause was deficient. This was raised by the will proponents themselves. They had a request for admission, which was basically, do you find this attestation clause defective? Again, the attestation clause does not say that the witnesses observed the person to be of sound mind. That piece of evidence doesn't stand alone. It's just part of all of the evidence. Ms. Kaforey was the scrivener, and during her deposition she testified she rarely did wills for wards, that Michael had had handwritten lists of names and they'd done multiple drafts of wills. None of those handwritten lists or multiple drafts were offered in evidence by the proponent, which permits us an inference that that evidence claimed available would not have been favorable. But the evidence we affirmatively offered to stop summary judgment, Mary Barnes' affidavit, which states, at the time of signing each of these wills, including the one contested, my son was not competent. I've been his guardian. She testified during deposition, I've been his guardian. I've known him all his life. And he is not competent and was not to make a will. Exhibits that were undisputed by the movements for summary judgment, an expert medical evaluation of March of '08, an expert medical evaluation of March of '07, Kaforey's own withdrawal from guardianship in September of '08, and the appointment of a new guardian, Mr. Hutchison, in January of '09. The disputed will being May 29 of '08 or '07, depending on which interline controls. That those affirmative items of evidence stated that Mike was not competent to make a will. Mary's deposition again, she affirmed she'd been his guardian, and her son, she knew, was not competent. Kaforey, Mary claimed that Kaforey told her, Mary, that Mike's not competent to make wills, and that I'm making these wills, as Mark, the other son, testified in his deposition. I'm afraid of Mike. She would say he would come in the office, he would be disruptive, he had to make a will, and the easiest thing to do was to make it and let him go. And that's what they said. Both Mary and Mark said she said. Now, do we know it was said? What weight do we give that? It's an evidence that a jury or fact finder should listen to. Ms. Kaforey certainly said. She never said that. So right there.
Did it also allege that she said the will was not valid?
Correct. And it was also alleged and not disputed that Ms. Kaforey had referred them to someone to contest the will. There was evidence in the record that Michael at one time was literally thrown out of Attorney Kudachev's office by the police for being disruptive. So the disruption wasn't just with Mary. Mike had problems. Mr. Zers, on behalf of Dakota Gage Bender, pointed out in his briefs that the trial court had ID'd the issue in this case as the evidence should go to the time he signed the will, limiting the evidence, or at least saying that's what she viewed as the important evidence, to the time of the signing of the will. This court in, I think I'm pronouncing it correctly, Dowdell, it's cited at page 33 of our brief, this court made it very clear, and some trial courts would probably complain, this court said, no, the evidence has to be a reasonable time around the signing of the will. To my knowledge, this court's not said what a reasonable time is, and in its own articulate way, the 12th district in Crodosian said that we cannot say that 13 months is an unreasonable time. Despite the double negatives, I think that court was saying 13 months might be a reasonable time for the evidence to fit into, not just the day of the signing of the will. Kaforey's brief pointed out at page 8 that first conceding 24 months might be a reasonable period of time, and then at page 16 saying, well, no, it's 6 months might be a reasonable time. But even Kaforey's brief agreed that the evidence should not be limited to the day of signing. Now, the elements of undue influence were found by both the movements and the trial court to be, quote, no evidence of undue influence. But on the contrary, their own evidence raised the presumption of undue influence. They offered 3 wills in evidence. Kaforey's only affidavit, besides her deposition testimony, her only affidavit was to authenticate a 2006 will, at which time she had made herself trustee of trusts the will would create and executrix. And clearly, under the professional guidelines in effect prior to February of 2009, those guidelines would control that 2006 will. That's improper influence. You, as an attorney, you should not do that. Name yourself trustee and guardian, and executrix. That was also, she named herself executrix in the other 2 wills. She described in detail in deposition her standard practice in execution of wills. The problem is her description of standard practice does not say, I advise the client, I don't have to be your executor. You can pick whoever you'd like. That was not included in her description, and it should be. James Hutchison stated that on a number of occasions, they went to Attorney Kudachief, he and his brother, after Dakota Gage Bender was adopted, and James lost all of his parental privileges. They went to Kudachief and tried to change the will. And Kudachief told them, Mike can't even make a will. So we can't change because he can't make one. Mark Hutchison was, albeit his feelings for his brother control, was harsh in his assessments. He felt Kudachief and Kaforey both were orchestrating events. Whether you believe that to be credible, or whether I believe that to be credible, it's not our job to determine the credibility of those allegations. It is the fact finder's job, in the presentation of the evidence, to consider whether or not that is credible. Mark Hutchison specifically said he believed that they were influencing him for the dollar perspective of administering estates, and if Kaforey suggested a will challenge, and whether those things are believed or not by us, and we don't want to believe them, they're not our decisions to make. If it pleases the court, I think my time has expired, and I would like to reserve the balance of my time for rebuttal. Thank you.
Fine, thank you. Who would like to begin?
Good morning, Your Honors. May it please the court. I am Richard Kudachief. I represent Ellen Kaforey as the executrix and the estate of Michael S. Hutchison. Your Honors, first of all, I do want to apologize for my tardy attendance here, but the Court of Common Pleas thought they had priority over this court.
That is nothing new.
You
No, I'm
moved right through it.
May it please the court.
We're all important. Go
Yes,
ahead.
of course. Your Honors, this opportunity today on these issues gives this court the ability to define when is a period of time that is important for consideration of the notion of competency of a person to execute a will. It does give this court some opportunity to, make some refinements here. To tell us, is it a day? Is it a week? Is it a month? Is it 5 years? Like the appellant wants you to believe? What evidence provides legal competency? We have here what seems to be an indictment on attorneys. So you're going to have to believe not only did Ellen Kaforey do things that are so outrageous, that was relied upon and or changed Michael's perceptive of how to give testamentary result for what he wanted to do. I've known Michael since 1985. I've known Attorney Kaforey since 1990, almost as long. Ellen's duty is to defend the will. We have no dog in this kennel show. Michael wanted what he wanted. What Mr. Ludwig has failed to mention about Michael is Michael was a very loving, caring, giving person, and he concerned about others. Yes, he was giving, and he did, want to do for others what was the right thing. It's uncontroverted that Michael knew who his family was. He knew how much money he had. He knew who he was giving it to, his brothers.
But he couldn't manage that money. He knew how much money he had, but yet the court said it's necessary to have a guardian to control everything because he is not competent to do it on his own.
Well, your point is great, Judge, except the notion of a guardianship goes to the management and assistance of a person. Just because I want to spend money left and right doesn't mean I am not competent to take care or have the ability. Michael went shopping. He took care of himself at his own place. He lived alone, under the guidance, yes, Your Honor, of
But is
Ellen.
that why we have that presumption?
It is, but in this instance, that presumption was clearly overturned. It was rebutted by all of these things that I'm talking about right now. He left money to his parole officer, his probation officer, to a
How
charity.
was that rebutted by saying he left money to all these different people?
Well, that has to do, if you take a look at the big picture of everything, you can see that his ability to live on his own was demonstrative of his ability to have testamentary capacity. So the appellant says, no, he does not have testamentary capacity, but let me ask you this, Judge. Do you think Ellen Kaforey made all this up? Why would she make this?
Oh, but that's not, isn't that a credibility thing? Isn't that what you argue to a jury?
I'm sorry?
Isn't that what you argue to a jury? Because the whole point is, when you say things, and I mean no disrespect, you know, I've known you for years, like you said, I mean no disrespect, but when you say things like, well, I've known this person for years, I've known this person for years, and why would they have any reason to make things up? Those are things you argue to a jury, aren't they? Aren't those credibility issues?
They are, unless you have uncontroverted facts, which we have here. Let's talk about, for the moment, the railing
And
diet.
I'm gonna stop you just for a second. Have you guys divided up your time?
I'm sorry?
Have you divided up your time?
We have,
Okay,
yes.
so,
Judge,
I don't have to reel you in or anything?
the rambling diatribe against Ellen Kaforey is unfounded. It's preposterous. Let's talk about evidence for a minute, because you're asking about that, Judge Carr. You're talking about the notion of, well, this should be argued. Let's talk about the evidence, you know, and the appellant doesn't really like evidence. They don't want to talk about evidence. You hear these things, well, Michael this, Michael, what does Michael in my relationship years later have to do with anything? Nothing. Let's talk about May 29th, 2008. There's no question of material fact that can demonstrate Michael had incapacity, that he didn't have appropriate capacity. Mr. Ludwig will have you believe somehow that there's a question of fact to his competency. What evidence is there? Michael could not help that he was mentally ill. He couldn't help that he had...
Aren't you simply saying that he couldn't help that he was mentally ill? Doesn't that go toward incompetency? And wouldn't that be a fact that needs to be found?
It would, Your Honor, and that's why I'm directing you to the evidence. Please scrutinize my brief, which is very detailed. Let's talk about the evidence for the moment. The evidence of incompetency. What is the evidence of, well, his mother said he was incompetent. His mother said, well, he's mentally ill.
Well, she's known him his whole life.
Judge?
And that's validated by court proceedings, right?
No, Your Honor. To
It's
the
not,
very,
he
no.
wasn't incompetent?
Judge, I ask you to take a look at the
Okay.
record.
I will. We
And
all
let-
do. We take it very, just for you to know, we go through it with a fine tooth comb, just for you to know.
Of course I know that. And what I'm pointing out is, in the record, you're not going to find any evidence whatsoever that the appellant, the brother, the father, any brother saw Michael in 24 months before or after this signatory. Now that's critical and that's significant.
If he was no longer incompetent, then why did he sell the guardianship?
Judge, competency relative to management of person, estate, and a guardianship does not go to the notion of competency to execute a will. Let's talk about the evidence relative to competency. You know, when
To
it gets...
execute a will, let's make sure we're talking apples and oranges.
Right, we're talking about the ability, because the appellant says Miss Michael was incompetent to sign a will. There's no evidence to that. Let's talk about Dr. Hermanowski, his treating psychiatrist. There is no evidence. Let's talk about any medical records. There is no evidence. If mental illness and drugs were a preclusion to having a lawful will signed, I'm here to tell you there's not a whole lot of rock stars that are going to have an estate plan.
I'm sorry.
Most drug users don't have guardianships.
What?
I would venture a guess that most drug users don't have guardianships. They're not wards of a guardianship.
But Judge, you have to isolate yourself from the notion of a guardianship versus the ability. People who are under guardianship can very readily do a will. There's no evidence that
But
Mike...
what do you do with the fact, okay, let's just assume all that. What do you do with the affidavit from mom that says that his guardian at the time, Ms. Kaforey, said that the will was invalid and that he was not competent to execute a will?
Because that's incredible and it's preposterous.
Well,
At the
that's
si-
a credibility thing, isn't it?
No, it is not a credibility issue.
Why not? And that's what I want you to get. Why not?
Because at a summary judgment issue, Judge, the question is uncontroverted fact. There is no controverted fact relative to Michael's signature. There's no witness, there's no attestation witness. What Michael had at signature was a nurse and a lawyer. At the same time, Ellen Kaforey.
We're at half point. Do you want to save some time for the other?
Well, I don't have much more. Let me just conclude by saying this. The attack on Ellen Kaforey is the basis by which the appellant rests their hat. And I'm asking you to look at the evidence. There's uncontroverted facts, and that's why appellees, the state is entitled to judgment as a matter of law.
Thank you.
Thanks.
Your Honors, my name is Salvatore Puglisi. I'm representing Mark Jeffrey Headley. There are 3 wills in this fight. The 2008 will, Mark Headley receives $10,000. 2007 will, Mark Headley receives the sum of $10,000. And a 2006 will, which Mark Headley would receive nothing. We filed for motion for summary judgment. No response was made. Last week in Bayview versus Woods, the court said in light of an argument made in the lower court, they cannot conclude the court erred in granting summary judgment. As it relates to Mark Headley, he should have the benefit of his $10,000 bequest if either of those 2 wills are deemed to be valid for whatever procedure, through the appellate court procedure, or if the court remands. We're requesting that our summary judgment remain in fact, because there is no question of fact or law that if those are valid, he gets his bequest, either one of those. Thank you, Your Honor.
Thank you. There's about 6 minutes.
Thank you. May it please the court. My name is Rick Zers. I am counsel for Dakota Gage Bender. Dakota is 13. He is the son of James Hutchison, who was the brother of the deceased. My client is the residuary beneficiary under the 2006, the 2007, and 2008 wills, and also was to receive a bequest of $25,000 in the 2007 and 2008 wills. I'd like to discuss 2 issues. The first being the presumptions in this case and the shifting of the burdens between the proponent and opponent
I
of
would
the.
like to hear about that, yes.
And second, the waiver of the majority of the arguments that Mr. Ludwig has made today. There is a presumption this will is valid because Judge Stormer admitted it to probate. Now, there's a common law presumption that Michael lacked testamentary capacity because he was under a guardianship. But that presumption is rebuttable. And it can be rebutted if we can show that Michael understood he was signing a will, he understood his property, he understood his family, and he understood there were claimants against his property. Now, I don't even think Mr. Ludwig has argued we did not rebut that presumption. It was rebutted by the affidavits and testimony of Attorney Kaforey. Attorney Kaforey is a nurse. She's an attorney. She was Michael's guardian for 5 years, and she had almost daily contact with him. And she testified without any equivocation that when he signed these 3 wills, and especially when he signed the 2008 will, he was competent to make a will. So at that point, that presumption by common law is rebutted, and the burden shifts back to that side to show there's no issues of fact that Michael was incompetent to sign a will. At that point, in summary judgment, they have to show there's genuine issues of fact that Michael was incompetent, that Michael did not have capacity to sign a will, or he was under undue influence. They didn't do that.
What about the affidavit regarding Ms. Kaforey?
The affidavit, if you would look at it, reads, the affiant states that her deceased son was mentally ill and incompetent at the time of the signing of the 2006, 2007, and 2008 wills. He was mentally ill. He was incompetent to the point where he needed a guardianship. But that did not make him unable to make a will. And Judge Stormer considered that affidavit in the context of the deposition transcript and the testimony.
What did she go on to say?
Mrs. Barnes, the appellant here, moved to Pennsylvania in 2005. had sporadic contact with her son. She admitted she was not present when Michael signed these wills. She admitted that she can't remember the last time she talked to him before he signed the will, or the first time she talked to him after he signed the will. Now, there's a controversy here between issue and evidence. The dispositive issue in this case is, are there factual issues concerning Michael's competency to make a will when he signed this will?
And that's what I'm getting at, because like you said, Ms. Kaforey is a nurse and an attorney, and you're relying heavily on her evaluation.
Correct.
Obviously, because she prepared the will.
Correct.
But what I'm saying is then, isn't there evidence? I'm not talking about whether it's true or not, but isn't there evidence presented to the court that she said something different about his competency to
I will.
going to his testamentary capacity? That's what I'm asking.
I think what you're asking me is, in the depositions of the family members, they allege that
Well,
Ms.
I'm sorry,
Kaforey,
maybe it was a deposition.
right, told them after the wills were signed that, hey, he's incompetent to sign these wills, I just did this to appease him. That argument wasn't made in the trial court. It wasn't raised.
So when we read the summary judgment motions and the responses and everything, we're not gonna find that anywhere.
You're not going to find that in the motion, in the opposition to summary judgment that was made by Mrs. Barnes. She presented 19 exhibits to the court, 14 of which were unauthenticated medical records that ended in 1994.
Okay, I'm misunderstanding you. You said it wasn't raised, and you said it was raised.
No, it was not raised in her opposition to summary judgment.
Okay.
What she did proffer to the court in opposition to summary judgment was 19 exhibits, okay? 14 of which were medical records that ended in 1994. She did not make the argument that Ms. Kaforey had told the family members that the wills were invalid, that Ms. Kaforey allowed Michael to sign these wills to appease him. That was not raised before the trial court. So,
Is there anyone, I'm sorry for interrupting, is there anyone else that needs to argue?
I don't think so, Your Honor.
Okay, then you have about 45 seconds.
Okay.
Sorry about that.
The evidence that was competent was Ms. Barnes' affidavit, an expert evaluation, a correspondence, and a certificate of death.
And when you say competent, you mean that was
Properly presented to the court, that's what I mean.
I'm sorry, we're using the competent. Oh,
I apologize.
That's okay, that's okay.
None of those documents, none of that evidence got to the heart of this case, which was Michael in a position mentally, physically, and emotionally to be able to sign a will on 5/29/08. The only evidence that was before that court was the testimony of Ms. Kaforey, because she was there, she was his lawyer, she was his guardian, and she had his best interest at heart. Nobody else in this case can even recall the last time they saw Michael, either before or after that will was signed. So it's our position that,
Thank you, counsel.
thank you.
You have actually 3 minutes and 40 seconds.
As much as you may find this hard to believe, Attorney Kudachief and I agree on something. We agree this case does present the opportunity for this court to clarify what a reasonable time period is. Fortunately for Mrs. Barnes, this court should do so in the context of, by saying what it not is. And it not is the immediate moment of signing of the will that same day. Because at that point, we don't have any will challenges, provided there's 2 witnesses. The doctor did testify by way of 2 reports, March of '07 and March of '08, when he reported to the court that this guardianship has to continue because Michael's not competent to handle his own affairs. And should we have called the doctor? Well, there's always going to be something we should have done if we're trying to support a grant of summary judgment. But there was testimony by a psychiatrist through those exhibits that said Mike was not competent. In deference to Mark Headley, it is not clear that he gets $10,000. Read the will. Apparently, one part of the will says this person gets 100, this person gets 100, this person gets 100. The next paragraph says, these persons get 25, these persons get 10. Everybody has read the word each into that draft. They ain't there. And in point of fact, if you look at the will, the argument is on its face when he intended each, he said each. 100 to you, 100 to you, 100 to you. 25 to you three. Well, Mr. Puglisi's saying, I'm automatically entitled to 10. No, by my math, it's 16-6. Okay? And on top of that, the first two wills have they are in evidence, we agree, they are in evidence. They have no presumption of validity. We'll cross that bridge when this court provides the opportunity to by saying there should be a trial on the 08. Are they still going to offer the 07 and the 06? I don't think so. They're going to rely on the 08. So those wills are not presumptively valid. They're entitled to no presumption. Sporadic contact, there is nothing in this record that said Mary's contact with her son was sporadic. Mary was no longer guardian from 05 when she moved out of state and understood she couldn't be.
And you need to wrap it up, you're out of time.
If it please the court, there is evidence in this case opposing summary judgment. And that evidence is uncontested. We'd ask the court to reverse the grant of summary judgments and remand this matter for proceedings consistent. Thank you, Your Honors.
Thank you all for your presentations to the court. We will take the matter under advisement and issue a written opinion and also release our opinion electronically on our website. Thank you.
Thank you.
Thank you, Your Honor.